So your book defines criminal justice as the system of law enforcement, adjudication, and correction that is directly involved in the apprehension, prosecution, and control of those charged with criminal offenses. Break that down real simple. It's law enforcement. Adjudication is a court process. So to be adjudicated for an offense is this is similar to being charged with an offense. But it's the court process. So it's when you go to court and the judge hears it and you plead not guilty. That's adjudication. The correctional system, 3 aspects that we talked about. It's involving the apprehension, again, law enforcement, prosecution, courts, and control of those charged with criminal offenses, corrections. 3 systems you need to know about, and that's it. Your book talks about the start of the criminal justice system, the history behind it, and I do talk about that. I appreciate history because, it does not always repeat itself, but it does rhyme. So something that Mark Twain once taught me very long ago. It does not repeat itself, but it does rhyme. We need to know the history of criminal justice to understand the issues that we're experiencing within this system right now. So, what I want to hear, and I think you all can still talk, but when you hear about justice, what is justice? How do you define it? Who defines it? What does it consist of? When I say what is justice, just pop off to me. What do you think it is? That is how we formally like to define justice: the retribution or repayment for crime committed. Who defines justice? Somebody else. Tell me, who defines justice? You were completely correct there in that statement. It changes over time. It changes by culture. It changes by who's in charge. Who defines justice? It's the people in power. Your politicians. All right, our politicians define justice, okay? Politics and criminal justice go very much hand in hand. It is still very, very unlikely that you're going to find a politician who isn't tough on crime, right? There was a big movement of that, particularly like in the 90s and the 2000s. Politicians want to be tough on crime, more so in the 90s. But it was because people wanted to feel like they were being taken care of, that the criminal justice system was implementing justice in a manner appropriate. And so who defined justice was the politicians, the people creating the laws and the legislation and creating and deciding the sentencing structure of those involved in the criminal justice system. How do you think we as a society view justice? I think you're right. It can be very one-sided. So, people want retribution, they want repayment, they want justice. And that's usually from the perspective of the victim or people who have been affected by crime. And so when we talk, we're going to talk about it as criminal justice professionals, but also as people in society, because we also have to understand and humanize the people in our society that, vote for our laws and are the people who essentially are supposed to be represented by our politicians who, when they make enough noise, are heard. And so, this tough on crime, eye for an eye, this came from people in power. This came from people who were affected by crime. And it was very much in the sense that, like, when it happened to you. History of criminal justice. This is something that you also kind of expected to know, the important dates. And kind of, I may not ask, I'm not going to ask like a multiple choice question of like, ooh, what year did Boston create its first federally funded police department? And it's gonna be like 1839, 1838, 1930. I'm not gonna do that. That's rude. Those aren't the kind of tests I do. So I really just want you to understand the timeline, and I want you to know the order of things. So in the 1700s, we had what were slave patrols and night watch. This was predominantly over in, can everyone still hear me okay? Am I still doing okay? I'm good? Okay. England, UK area, what we follow when we're talking about the history of criminal justice. If it's not the UK, it's America. Those are pretty much the 2 areas in terms of history that created our criminal justice system. Slave patrols and night watch is how the system began. Night watch being basically voluntary positions at nighttime that people would just kind of keep an eye out. It wasn't very organized. It wasn't very well led. A lot of people who were volunteering were often drunk or drinking or sleeping on the job. It wasn't like legit. The slave patrol were the same thing. Over in the U.S., where we had slaves when they ran away had to be caught and had to be brought home, and that was the first type of kind of like patrol service in the U.S. And also that was like indentured slaves as well. So not just mean African American slaves, I mean indentured servitude as well as the African American slave trade. Move forward from the 1700s, it wasn't until 1829. That is less than 200 years ago. Remember that. That is less than 200 years ago. 1829 is 191 years ago. That was when London created the Metropolitan Police. That was our first example of what a police department should run and function like, essentially. Because the U.S. had broken away from England, that concept did not jump the pond very quickly. It took about 10 years for the London Metropolitan Police Department concept to make its way over to the United States. And we didn't see that until 1838 in Boston. From 1838, which is the official development of U.S. police law enforcement in the mid-19th century, we saw it further evolve. And so you had in the early 1900s the Chicago Crime Commission. You had the National Commission of Law Observance and Enforcement. We saw in 1967 the development of the Federal Law Enforcement Administration of Justice, which was the Crime Commission. So a lot of this came into fruition in the 1900s. I want you to really think about that. Now think about it in this term. 1931, your grandparents were probably alive, I'm thinking. Right? Think about if you have grandparents or parents. Right? Think about the timeline. 1900s is not that long ago. It really is not. 1919, that's 100 years ago. So this still, we're talking about a fairly new system is the point of what I'm trying to make here. And so as the criminal justice system evolved and developed from policing and corrections and the court procedures, and mind you, these things were all changing at the same time, but differently as well. And so you have three separate entities of this system that have been under development most drastically in like the last 150 years. Just something for you to consider in terms of like this system that we think is just so ingrained in society, but is still something that, your grandparents were alive when the National Commission of Law Observance and Enforcement was created. So your book then talks about, as criminal justice developed, so did evidence-based justice. Evidence-based justice consisting of 5 things. Making sure you're very specific on your target audience of the program or policy that you're trying to implement. Randomized experiments, intervening factors that could enhance or impede the success of your policy or program. Measurement of success. How do you measure success, right? Evidence-based practices, you always need to be able to measure it. And then cost effectiveness. This is a huge thing. Money talks. Money makes the world go round. These are facts. They're not just cute little sayings that we like to say. They're facts. We will talk about how much it takes, to incarcerate somebody for a whole year. If they can save even a fraction of that money into a community-based program, that's what a lot of community-based programs try to prove now, is that they're more cost-effective than institutionalizing somebody. And that's another major factor. And so for an evidence-based practice, which is a little image I have here for you, it's talking about the best research evidence, clinical expertise, and patient values and preferences. Same summary, different words. All right? Don't get yourself confused. The target audience would fall under patient values and preferences. The randomized experiments fall under clinical expertise. Intervening factors, best research evidence, measurement of success is also going to be that clinical expertise, and cost effectiveness is going to be best. It's going to fall under. It's always be included. If you want something to pass through the House, if you want something to pass through legislation, you absolutely want it to be cost effective, because everyone wants to save money, especially politicians. So, contemporary criminal justice. We saw this on Tuesday. But contemporary criminal justice is law enforcement, court systems, and corrections, all of which have we're gonna break these down. Mind you, we're just talking introductions, we're just talking the basics right now. As we move forward with this class, we are going to break down the development of each of these separate entities within the criminal justice system, starting with law enforcement, which is why I kind of emphasized law enforcement up here, because I want you to really understand the development of these systems. And so when we talk more about courts, when we talk more about corrections, we'll go through their timelines as well and really talk about their development. And so just make sure you understand criminal justice system, either the three entities. This is what you need. And they operate separately. It somewhat mirrors the, like our, when we want to talk about our government system, we have like our legislative branch, our judiciary branch, and our executive branch, right? It's similar in that way. They operate very separately, and they actually are meant to hold each other accountable, even though they don't always do that. The formal procedures. Now, somebody showed me an image in your book. I don't know if this matches up. I'm really hoping it does. The formal procedures are it can be very confusing and daunting. So we're going to spend a little bit of time on this, okay? Let me break this down. So when I'm arrested, there is a police report, and I'm charged. Usually, I was charged at the scene. Police report's issued. It is reviewed by the deputy district attorney at the time, and we're going to move forward with this. We're going to charge them. All right. So I go forward. I had to be charged based off my offense, and I had to go in front of a judge, and the case was issued. Carmen A. Rivera, you're charged with blah, 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 blah. Do you plead guilty or not guilty? And so I got a public defender at the time, and he advised me to plead not guilty, which I pled not guilty. And so there was a bail review at that same point. Sometimes bail reviews are at the same, like they ask like plead guilty, release on recognizance, or whatever. If you're going to be released with bail or on your own recognizance, which is essentially being released on your own merit, knowing that you will follow through with the court proceedings. And so I was pled not guilty, no bail. I was released on my own recognizance that day, because what a lot of plea bargaining can consist of is plead guilty now. You'll be on probation. You'll do whatever we ask you to do, and then it'll be a sponge from your record. It's called kind of like a deferral. That is how a lot of cases actually work. It's a relationship. It is what we talk about the what was the word? The court workroom. The courtroom workroom? Courtroom? Yes, the courtroom work group. Say that 4 times fast. The courtroom work group. So as attorneys, really, they work together behind the scenes a lot of the time. So now if I had been charged with a felony and we weren't able to come to an agreement, that is where, possibly you would see it go to trial and there'd be a jury, and that's a very small percentage of cases. Majority of cases, it's negotiations behind the scenes between the defense attorney and the prosecutor. Essentially, the prosecutor wants you to plead guilty to something. They want you to plead guilty because a guilty plea to them is a win. That's how they see it, plain and simple. You plead guilty, I win my case. That's all. And so when they don't get that, that's when the negotiation comes in. Okay, you're not going to plead guilty. What are we going to do? How are we going to implement justice? These are the informal procedures I'm talking to you about. The courtroom work group, which is a lot of times just the attorneys working together behind the scenes. There was a good show, actually. I think it only lasted, it was a Shonda Rhimes production. It only lasted like 2 seasons. It was called For the People. If you want a show that shows kind of the inner workings of like the informal procedures of the courtroom work group, I would say go Google For the People. The show only lasted 2 seasons. It's really entertaining to watch, but actually is like is not terribly egregious. It's actually pretty like, okay, like this is real. Like obviously you can tell what's unrealistic. You'd be surprised. Those dramatic closing procedures and opening statements that we see on TV aren't actually that far off. Lawyers are actors of the criminal justice system. All right, they have to be engaging like a professor. They have to catch your attention. They have to get 9 very like or 7, however many jurors they're dealing with, to pay attention to everything they're and to vote for them is what they're vote for this plea. Okay.
Okay.
And so those closing statements, even though they're very dramatized, yes, on television, sometimes they're really not. They really are actors. They are trying to show a story. In the Central Park 5 case, for example, they still had the victim testify, even though the victim did not remember a single thing about the night she was attacked. No memory whatsoever. Why do you think, as just introductional students, why do you think if this victim doesn't remember a damn thing about the crime, why would the prosecutor want them on the stand? They saw this victim that was badly beaten and bruised. They couldn't tell you anything, but seeing them plays on the emotion, plays at the heartstrings, plays at the people. That's part of acting. That's a part of the criminal justice system. It's really trying to get people to agree with you and agree like this person's guilty and they need to spend this amount of time incarcerated because they shouldn't be out in the streets for this reason. The wedding cake model, which is here on the screen. Beautiful image in your book, I believe, and it also is very realistic. Like majority of the criminal justice cases, but like DUIs, property violence, little misdemeanor things. Less serious felonies, more serious felonies are near the top, and then you have your celebrated cases. Can anyone give me an example of a celebrated case? Yeah, O.J. Simpson. We'll talk about the O.J. Simpson trial a little bit because I mean, O.J. Simpson, that was huge when I was growing up. So O.J. Simpson, yeah. So serious felonies and less serious felonies are those in between cases. An example of a serious felony is going to be like your class A felonies, violent offenses. There's usually a victim. Less serious felonies, it might be a class B felony, and maybe more property. It might be a burglary. May not always have like a human victim. But they do sometimes. So don't associate less serious felonies with no victim at all. That's not true. Less serious felonies are usually just less severe. So child molest in the 3rd degree in comparison to rape 1. Child molest in the 3rd degree, less serious felony. Rape 1, more serious felony. You're going to see an offense name and you're going to think, okay, this is this. What I'm going to try to teach you here is that offense does not always mean that. Assault is on a spectrum of assault. Rape, there is a spectrum of rape. And oftentimes that is dependent on what we can prove and what we're willing to go to trial for and what like the attorneys are willing to fight for. Which, when you are charging somebody in the 1st degree of something, there has to be that proof of premeditation most oftentimes. And that can be more difficult to prove than not.